Can a Florida workers' compensation claim be denied due to marijuana use? As marijuana laws have evolved over recent years, especially with the acceptance of medical marijuana in many states, the impact of marijuana use on various legal spheres has come under the microscope. One such domain, particularly relevant for Florida residents and employers, is workers' compensation. A lingering question remains: can an individual's workers' compensation claim in Florida be denied due to marijuana use? Marijuana in Florida. A quick recap. Florida passed the Florida Medical Marijuana Legalization Initiative Amendment 2 in 2016, which permitted the use of medical marijuana for individuals with specific debilitating diseases or comparable debilitating conditions as determined by a licensed state physician. However, it's crucial to recognize that recreational marijuana remains illegal in the state, and the federal classification of marijuana as a Schedule I substance adds another layer of complexity to the conversation. Marijuana and workers' compensation. Navigating the nuances. Injury and impairment. In the realm of workers' compensation, a primary concern is establishing a direct link between an injury and any form of impairment, including that which may arise from drug or alcohol use. If an employee suffers a workplace injury while under the influence of marijuana, it becomes a central issue to determine if marijuana played a role in causing the accident. It's worth noting that, unlike alcohol, THC, the psychoactive component in marijuana, can remain detectable in the body days or even weeks after consumption. This long window complicates the process of determining actual impairment at the time of the accident. Drug testing post-injury. Florida law allows employers to conduct drug tests after a workplace injury. Should the results return positive for drugs, including marijuana, there's a presumption that the injury was caused due to the impairment. However, this presumption can be rebutted. The employee might have the opportunity to demonstrate that the presence of marijuana did not contribute to the injury. Given the complexities of THC detection, this becomes a potentially contestable area. Medical marijuana patients. For employees who are legally prescribed medical marijuana in Florida, the waters are murkier. While they are protected under state law from certain forms of discrimination due to their status as medical marijuana patients, it does not necessarily exempt them from scrutiny in a workers' compensation claim. If there's a reason to believe that the use of medical marijuana contributed to the accident, the claim might face challenges. Best practices and precautions. For employees, if you're a medical marijuana patient, ensure you're compliant with all state regulations and that your employer is aware of your status. Always be aware of how marijuana affects your ability to perform tasks safely, especially in roles that demand high levels of alertness or coordination. For employers, clearly articulate your drug policies, ensuring they align with current state laws. Offer regular training and resources on drug safety and awareness.
In conclusion, the intersection of marijuana use and workers' compensation claims in Florida presents a dynamic and multifaceted challenge. While marijuana use, especially when tied to impairment, can indeed play a role in the evaluation of a claim, each case is unique. For personalized advice and representation, individuals are encouraged to consult with legal professionals well-versed in Florida's workers' compensation laws. At avardlaw offices, our team is equipped to handle the complexities and nuances of such claims, ensuring that the rights and interests of all parties are effectively championed.